This is Erica Merrill, and I'm the founder of Perfect Legal Video. And I'm very excited to bring to you attorney Brian Jones out of Ohio. Today, we are going to be talking about information surrounding domestic violence. And welcome to the show today. Thank you so much for joining us, Brian.
Thanks for having me, Erica. It's good to see you.
Yes, good to see you. Now, if I'm accused of a domestic violence act, what happens next?
So generally, following an accusation is an arrest. Under Ohio law, it's a mandatory arrest and detainment until the accused person can be brought before the court. So if you're accused of domestic violence in almost every circumstance, the next step is an arrest and a trip to jail.
Wow. What if my accuser doesn't want to press charges? I know that happens a lot of times between a husband and a wife, or a boyfriend and a girlfriend. They're in a heated argument, something happens, and then she changes her mind either of her own will, or sometimes she's forced to change her mind. What typically happens in those cases?
Erica, I would venture a guess that more than 50% of my cases come from situations where a husband and wife get into an argument and somebody gets so mad during that argument that they decide, I'm going to get one on him and I'm going to call the police, or I'm going to get one on her and I'm going to call the police. And they're just doing it as a threat, and they're just thinking the police are going to come out and they're going to cool us down and everything's going to be fine, and the police are going to go away and say, look, don't do this again, because we don't want to have our time wasted. And what happens in every single one of those circumstances is somebody gets hauled off to jail, and then the person that made the call, the accuser, regrets that decision real fast. And in those situations, the accuser doesn't have control over what happens with the case. Ohio is what's called a no-drop case. So just because the accuser wants the charges dropped doesn't mean that the charges will be dropped. And in those situations, the accuser will often be the individual that hires us. And Ohio has a victims' rights constitutional amendment. So what we do is we work not only to ensure that our clients' rights are protected in the criminal matter, but that the accuser is respected and afforded what is entitled to them under the Ohio Constitution as well.
Oh my gosh, I had no idea that it was that high, where 50% of the cases are just somebody trying to get revenge on the other person and just really showing them and putting them in place by calling the police. That is terrible. And so they don't realize when they do that the fate of their husband or boyfriend or whoever it is not going to be in their hands. They cannot take it back so easily, because whatever they say is going to stick until they get into court and prove things otherwise.
Well, those are the cases that my office handles. And that's anecdotal, but I would venture a guess that a lot of cases are that situation. Time and time again, I have individuals come to me and say, I had no idea that the police would take my spouse away. I had no idea that the police would come and take my children away. Because remember that domestic violence is not a crime exclusively between romantic partners. If a child, acts out and, has an action towards a parent, that can be charged as domestic violence. And likewise, parents against their children can also be charged as domestic violence. Brothers and sisters, even in some cases, long-term roommates can be accused of domestic violence.
So are cases that are domestic violence different in some way to cases where you just happen to be out in public and somebody gets in a fight?
They are, because domestic violence counts as a misdemeanor crime of domestic violence. So they carry additional civil consequences, which is loss of your Second Amendment rights if you are ultimately convicted of it. Under Ohio law, a misdemeanor, well, under Ohio and federal law, a misdemeanor assault doesn't strip you of your Second Amendment rights, but the domestic violence charge does. So that's the big consequence that's different between assault and domestic violence.
Can you remind the audience what the Second Amendment rights are?
Yeah, your right to bear arms. You get stripped of your right to own a gun, possess a gun, engage in any firearms transactions. And I know, Erica, we're going to discuss in another panel people's Second Amendment rights and how to restore those if they've been stripped from you.
Now, I know this isn't part of your questions, and I'm just digging a little deeper as someone that is not an attorney. So hopefully I'm asking questions that some of the audience might have. Um, but if somebody gets taken off to jail, this is obviously going to affect their life in ways that probably their accuser didn't even think about, which is, possibly they will have a criminal record, which, as we've spoken about in some of our past interviews, can really affect the types of jobs that you can have. You might be working in a car wash and is really an attorney. What if it's a police officer and now their Second Amendment rights are taken away? What happens to that person then? Can they go back and do that job again? I mean, there's a lot of little questions that I have about what happens to somebody's life once they are accused. Now, of course, I know that you can prove it all wrong and, maybe they get all their rights back. But in the meantime, it sounds like it could really mess up someone's life.
It absolutely can, Erica. And that's why you want to get an attorney involved who approaches your case holistically. And that's why we take a holistic approach to all of our cases. Many attorneys work in the court realm only. They go in and they negotiate with prosecutors and maybe they even try cases, although not all criminal attorneys are willing to try cases. But the way that we approach our case and the way that we represent our clients is we're the attorneys that will reach out to your employer and say, look, this is an accusation only. My client is a good employee. My client has a long-standing reputation with you. My client excels at their job. Now, you may need to put my client in a different position for a time period. You talk about the law enforcement officer that can't carry a weapon. You talk about the individual who, maybe they don't want a public-facing position during the time that the allegations are pending. But we take that holistic approach to make sure that our clients' lives are disrupted in the minimal way possible. But the reality is that even going to jail for 24 hours can absolutely destroy a person's life who is a wage worker and now has a no-call, no-show on their employment history, which can result in their termination. People lose their children and they can't see their children for long periods of time. The consequences of making these allegations when it's used inappropriately are so broad and so deep that I really encourage people to think twice. If you are truly an abused person and you need the help of law enforcement, absolutely reach out to law enforcement. Domestic violence is a crime in America that too often escalates to more serious crimes. And not only that, but it's a crime that is often kept in secret. But domestic violence allegations, simply for the sake of ending an argument or getting an edge in a relationship, should never happen. And they really are a blight on our criminal justice system.
Now, and thank you for that response, because that is, it really answers a lot of questions, but also just really shows us what a dire situation this is to falsely accuse somebody, or, to maybe, instead of calling the cops, if it seems like something that can be de-escalated on your own, and, that way you're not going to be missing out on wages that might be helping that family income and pay bills for that household, as well as having to pay out money for attorney's fees, which can bankrupt people in some situations.
Absolutely.
So the next question I have is, I mean, you've touched on so many things where, hey, people may not be able to see their children because of this criminal charge. So, for example, in that case, maybe they're not allowed to go back home. I mean, and there might be other reasons for them not being able to go back home. And I'm going to let you give me those, but like, what should they do in that case?
Erica, that is one of the most difficult questions that I ever have to answer for a client. When the court imposes a no contact order, a stay away order from a house, a stay away order from children, my clients often come to me and say, how can we get this fixed? And the answers are as varied as the families are out there. Oftentimes we have to go into domestic court and get a custody order from the domestic court, or a visitation order from the domestic court, in order to get people back in touch with their children, even if their children had nothing to do with the incident, weren't present at the time of the incident, weren't even in the same household at the time of the incident. Those stay away orders can be applied to children. When people are removed from their homes, the suggestion that we have to make is, you're going to have to find a friend, you're going to have to find a family member, and if there's none of those available, you're going to have to stay in a hotel, maybe a long-term stay, maybe rent an Airbnb for a while. Those are the sorts of situations that get really, really difficult. Fortunately, we can also go back to the court and ask the court to modify those stay away orders, modify those temporary protection orders or those criminal protection orders, to try and get families reunited.
Well, that's really great. And that answers one of my other questions, I think, which is, what if my boyfriend or girlfriend, wife or husband really relies on me to help with the childcare and that sort of thing, and I have this order against me, what can I do to reverse it?
Yeah, so we can file a motion to modify that protection order. Sometimes those protection orders are conditions of bond. Sometimes those are actual criminal protection orders that are issued in a more formal manner. Having the support of the accuser to modify that is incredibly important. And that's the reason we make sure that we reach out and offer to speak to the accuser and offer to bring them into our holistic plan for our client's defense, even if they still want our client prosecuted. Oftentimes they don't want the protection order against their children. They want the defendant to be able to have contact with the children, or they want the defendant to be able to assist with the children. Now, here's the real scary thing about that, Erica, is that we have gone into court. Prosecutor's on our side, accuser is on our side. Obviously, my client wants a protection order modified so that they can be able to help out with their children. It's still up to the judge. And I have gone before judges who have unwritten policies. They could never formally state that they would never modify a protection order. But in practice, that's the way it seems. There's a standard in the law called an abuse of discretion, which means that judges have to take all of the circumstances of every case into consideration when making these sorts of decisions. And the Court of Appeals won't disturb their decision unless they abused their discretion in that regard. And so they won't state it formally, but we know from practicing in these courts over and over again that they just have a policy. We know from having bench conferences and private sidebars that it's their policy that they won't modify these orders. And they have very little sympathy, it seems, for the consequences and the devastation that these orders reap on families.
I mean, I always hate hearing that. And I know that we've talked about this before, that some of these laws are on the books for decades and they don't get changed and they don't take into account the different situations, and the levels of severity might be very low in some cases, like where we were talking about somebody just got a little mad and wanted to you know, get revenge on somebody or try to control them by calling the cops. Um, you know, and then there are some real situations where, you know, someone really is going to harm them and they do need those harder protective orders. So what is the difference between civil protection order, temporary protection order, and a no contact order?
Yeah, so a civil protection order is generally issued by the Common Pleas Court here in Ohio. And it is a civil standard. It can be issued for up to 5 years. And it can come with conditions such as requirements to attend anger management or other therapies. It eliminates your Second Amendment rights to own a firearm or possess a firearm. And it can also include conditions such as um, ordering individuals to pay mortgages and utility bills for the duration of the order. It can order individuals to abstain from consuming alcohol or other drugs. So it's a more long-term solution that courts use to keep individuals away from us. Now, a civil protection order can be issued for a variety of reasons that don't require domestic violence, but domestic violence is one of the potential elements for the issuance of a civil protection order. Now, a temporary protection order, or what courts more formally call a criminal protection order, is similar in the sense that it can have all of those conditions, but it only lasts for the duration of the criminal case. Now, it is a separate order from the criminal case, and therefore it can be prosecuted as a violation of a protection order, which is another criminal offense, which also carries very serious consequences and oftentimes is very easy to prove on the part of the prosecution. Sending a text message, an email, an accidental butt dial of a phone number can all result in a violation of one of these protection orders. Now, you can violate a civil protection order as well. The last category, the no contact order, can't be prosecuted as a violation of a protection order because it is generally referred to as a condition of bond. So your bond can be revoked, and your bond can certainly have these other conditions: no consumption of alcohol, seek out an anger management or a mental health assessment. And while you're being prosecuted for these crimes, in many cases, you're not allowed to own a firearm. But it does not have the consequence of potentially being prosecuted as a VPO, violation of a protection order, if there's some contact there. And it also only lasts as long as the criminal case is in place.
Okay, so that, I mean, so they have at least some variety in these protection orders, and you know, that way it's not just like one blanket statement, you cannot go home, or they really take into account the situation that the person is being persecuted with at the time. Is that right?
That's exactly right, Erica.
So could you go to jail? And if so, for how long?
So the primary crime of domestic violence is a misdemeanor of the first degree in Ohio. It carries penalties of 0 to 180 days in jail. Now, we already discussed the fact that if you're arrested, then you will, if you're accused of domestic violence, more likely than not, you are going to be arrested and you are going to be taken to jail until you can be brought before a court for an arraignment and a bond hearing. So if you are accused, you are almost certainly going to go to jail for that initial period. The circumstances of the case determine whether you're going to go to jail for an additional 179 days after that.
Wow, that's a long time. Will you end up getting a felony on your record if something like that happens?
The first allegation and conviction for domestic violence is a misdemeanor of the first degree. One of the real sticky issues with domestic violence is that it's what's called an enhanceable offense. So if you are accused a second time of domestic violence, then it becomes a felony of the fourth degree, carrying 6 to 18 months in a state prison. If you're accused and convicted a third time for domestic violence, it becomes a felony of the third degree, carrying 9 to 36 months in prison.
Wow. So it sounds like it escalates appropriately, and in some cases, I would say, if you're being convicted several times, you should probably end up keeping everyone safe by staying behind bars. But I mean, and this is a question I don't think we have on the list, but do they have any programs to help the people that are going to jail just rehabilitate?
In the facilities, no, there really isn't anything other than AA meetings. Some jails have access to counselors, and the other inmates are the only people that people who are incarcerated are able to talk to. Frequently, in cases of domestic violence allegations, the courts will order an anger management assessment. And so those individuals will be sent to a counselor in order to determine if there are some anger issues there and how to appropriately deal with them. I do want to tell you, Erica, that these enhanced penalties is one of the most important reasons why you need to seek out an attorney, even if this is your first allegation of domestic violence. Too many people look at that designation of this crime as a misdemeanor, and they think, well, this is just a misdemeanor, it's not that big of a deal. And those are the individuals that come back to me facing a felony domestic violence, looking at going to prison and saying, but I didn't do this and I didn't do it the first time. And what I tell them is, you should have defended that case the first time around, because after that person got you tagged with this once, it becomes so much easier for them to tag you with it again. And it essentially puts a collar around your neck and puts a leash in their hand, that anytime you step out of line in the way that they want you to behave, they can jerk that leash and have you sent off to jail. It almost creates a role reversal in the traditional cycle of violence that we think of. And it becomes a different kind of cycle of violence where an accuser makes an allegation and the individual goes to jail. And oftentimes that first allegation is dismissed or reduced, but then they realize, I can have this person sent to jail. And so the second time the case is filed and they spend another 24 hours in jail, and maybe this time the prosecutor says, no, this has already been dismissed once, we're going forward with it. And so now they've got a conviction, but they go back because that's how the cycle works. And so now the defendant or the accused has gone back to that individual, and that individual makes yet another allegation. And now they're looking at a felony. And so it absolutely warrants escalation for those individuals that commit this crime repeatedly and are actually guilty of it. But that cycle of violence that we always hear about in domestic situations, it works both ways, both with the abusers and the false accusers. And so, you were really quick, Erica, to jump up and say, well, yeah, those people should absolutely be incarcerated for longer periods of time. And I agree with you 100%. An individual that commits this sort of violence on a repeated basis, even if it's something as minor, physically as shoving somebody, you don't have to bloody somebody's nose. You don't have to blacken somebody's eye to be convicted of domestic violence. It's that threat of interpersonal violence. It's that invasion of your private home space, like a burglary, that makes this crime so serious. And when that happens, it is absolutely some of the most serious criminal conduct that anybody can engage in. But the far-reaching consequences and the number of attorneys that encourage people to plea these cases out because it's just a misdemeanor, I think is a real shame in our criminal justice system.
Yeah, and I don't mean to jump up and say these things about people, because honestly, most of the time when we talk, I'm getting quite the education on some of the ways that people are put in a bad position, that is not entirely their fault. So if something happened where they did not get that first misdemeanor taken off of their record completely and they didn't fight hard, it sounds like then they're put in a bad position if any little thing happens, or if even somebody feels like lying about it, they're going off to jail, and it's going to take a long time and a lot of lawyer fees and court appointments and sitting around and losing income and respect in your community and everything else. And then basically your life is in somebody's hands. Whenever they feel like doing that to you, they can. And this is a whole side of it that I haven't seen. So I'm glad that you are discussing it with us today, because a lot of us only see what we see in the movies, really, or we hear second or third hand. But talking to you about these things, you see this every single day, and you know both sides of the story.
Well, yeah, and I really appreciate your courage in being honest with us about this, because it's what we're all thinking. It's what most of the people that are watching this interview are thinking, is that, you've been accused of this once and you admitted to it. So if you've been accused of it second time, you certainly did it again. And and I think it's really important for people to hear the reality of these situations, is that cycle of violence works both ways. And having somebody falsely arrested is violence upon that person.
Well, and I work with a lot of different types of attorneys, and we do a lot of interviews with divorce attorneys, family law, and they bring this up all the time. People will falsely accuse in those types of cases because they want more custody so that they can get more money, or they don't want to see their ex at all anymore, so why not just tell their kid to say something terrible about them and then they get thrown in jail. So I mean, there definitely are those cases, and I know that it doesn't always have to do with children, but there are plenty of examples of people manipulating the court system to get their way in those cases, as I'm sure there are in some of these other cases that you're talking about.
Absolutely. We frequently get cases that involve divorce or custody battle, and these sorts of allegations are used as leverage to get an advantage in those cases.
So if this happens, and what if the person is in the news, how can they get rid of that embarrassment?
Well, again, that comes right back to our holistic approach, Erica. We address every area of the situation that you find yourself in. We are not a court-only law firm. So you will frequently see on our website, on our Facebook and Twitter accounts, responses to prosecutors' offices trying to try their cases in the media. I think it's important for attorneys, and especially defense attorneys, to talk to reporters and make statements and say, these are allegations. These are not criminal convictions. They have not been vetted by a jury. They haven't even been vetted by somebody who's disinterested in the case. So, can you stop the embarrassment? No. But can you respond to it with a coherent and effective media message? Absolutely.
So I think that from everything that you've told me today, it's really important to talk to an attorney if even the smallest infraction comes into play, because of the adverse effects it can have later on if your relationship with whoever has accused you goes down the wrong path again. They could have that control over you and your whole life in so many different aspects of it. The best thing to do is to call Attorney Brian Jones' office. Now, can you tell the audience if they know someone or they themselves have this issue, what is it that an attorney can do for them?
Well, most importantly, we're going to stop the bleeding. The first thing we're going to do is triage the situation, and we're going to make sure that there's no further damage done to their reputation, to their social life, to their family life, to their employment. Then we're going to conduct our own independent investigation of the case. The police come out, they get one person's side, they try to extract a confession out of the person that's been accused, and they throw somebody in jail, toss a file over in the prosecutor's desk, and say, it's your problem now. Well, what we're going to do is we're going to do a full investigation of the case. What's the relationship history like? Were there any video recordings of this? Are there audio recordings of the incident? What's the motive of the individual to make the allegation? We're going to do a true objective investigation of the situation. And then we're going to give our client some honest advice. Sometimes that honest advice is, you made a big mistake. You need to go and get some counseling. You need to go and address this personal flaw. Sometimes that advice is, we need to go and talk to 8 members or 12 members of this community and tell them what an injustice has been done to you, and ask them to right that injustice through a not guilty verdict.
I mean, I think that sounds like a great plan. If you have any issues, to like sit down, come up with this holistic approach, figure out how to stop the bleeding, and then what the next steps are. And, having a good strategy is, oftentimes one of the best things that you can do in facing these kinds of accusations.
Precisely, Erica.
Well, Brian, I want to thank you so much for joining us today and giving us a lot of great background on domestic violence issues in court, and how you approach these, and how you really need to take every single infraction seriously and fight it if it's not true, and just to protect yourself from future situations. So really learned a lot today. Really appreciate your opening our eyes to some of this, and not just being so quick to jump to conclusions, but to really, look at the whole picture, like you guys do, and gave us a lot of great strategies. So I really want to encourage anyone that has issues like this to please pick up the phone, call Brian Jones's office. They are very professional. They do this every single day in court. They've seen it all. They stay up on the newest laws through a lot of continuing education and reading the news and just being in court every single day. So please give them a call, and they will give you a free consultation, and then you can figure out your next steps with you can make an educated decision with the information that you get from the office of Brian Jones.
Well, thank you for saying that, Erica. And I agree. Reach out to an attorney and consider our office. We're happy to help.
Thank you so much. And I hope everybody has a great weekend. We will be talking to you again very soon.